everybody. Panel 1 will discuss one-stop shop, centralization versus proximity. Please welcome Eduardo Ustaran, partner at Hogan, Lovells, Paul de Hert, professor, Free University of Brussels, José Luis Rodríguez Álvarez, director, Spanish Data Protection Agency, Dale Skivington, CPO, Dell Computers. Moderator, José Luis Rodríguez Álvarez.
Thank you. Good evening, everyone, and thank you for attending to this session. The topic of this panel, the one-stop shop mechanism, is one of the most relevant and at the same time one of the most controversial of the new data protection regulation that is being discussed in the European Union. Although it might seem an European issue, it could be also of interest in other supranational or regional contexts because it's a good test case for analyzing the problems of building a supranational decisions-making process based on interstate coordination and cooperation. To debate on this issue, we have an excellent panel of experts that will address it from the different, but I hope that complementary perspectives of industry, academia, legal profession, and supervisory authorities. Following the order and the program, we have to my left, Eduardo Ustaran, who is a partner of Hogan Lovells and a recognized expert in privacy and data protection law. Over there, we have Paul de Hert, professor, a well-known professor at the Free University of Brussels, and director and member of several research groups on law, technology, and privacy. And last but not least, Dale Skivington, executive director of global compliance and privacy at Dell. She has also an extensive career as lawyer in matters linked to privacy and civil rights. I myself am José Luis Rodríguez Álvarez, director of the Spanish DPA, and also with a professional background in law at the university and in the public sector. Well, I have been asked to act as both moderator and panelist, and so I will try to give you an overview on this one-stop shop mechanism, as well as to make a preliminary assessment of its pros and cons. The expression one-stop shop refers to the rule of jurisdiction contained in Article 51, paragraph 2 of the draft regulation. According to this provision, where a controller has establishments in several member states, the authority of the main establishment should be the only one competent to supervise all processing operations of that controller in the whole European Union. This rule leads to a concentration of jurisdiction in the authority of one member state, the one where the main establishment is located. And that introduces a substantial change compared to the present situation where each supervisory authority is competent to monitor all processing activities of all establishments in its territory. The aim of this change is, as expressed in the proposal, I quote, to increase the consistent application, provide legal certainty, and reduce administrative burden for controllers and processors. Together with this concentration of jurisdiction, the proposal sets cooperation mechanism to reinforce mutual assistance among DPAs and a new consistency mechanism to enhance the coherence of decisions that may have an impact at EU level. An additional and very important consequence of this new criterion is that decisions made by the main establishment authority may only be challenged before the national courts of that DPA. It is evident that this system has a number of important advantages. In principle, DPAs will not duplicate their work when dealing with the same issues in relation with the same company. Although all concerned DPAs should be involved, only one of them will have to take on the responsibility for preparing and making the decision. At the same time, one single decision that is valid for the whole European Union would be, in principle, more effective than several decisions by different DPAs, which may be inconsistent or even contradictory among them. But the main effect of this new system will be more simplification for companies. They will have one DPA as contact point within the European Union and will have to adjust to only one set of laws. As you can see, the advantages of the envisaged system have in common that they mainly operate in favor of companies. But things are slightly different when considered from the perspective of the individuals. For citizens, there is a loss of proximity. Decisions affecting their fundamental right to data protection will be made by administrative or judicial authorities that are not the ones of the country of residence of the data subject. This creates legal and practical problems. Data protection is not only about applying data protection laws. It's often necessary to apply concurrently provisions of sectoral laws in fields such health, labor, or finance, which are not fully harmonized at the European level. Procedural, administrative, and judicial law also vary from country to country. As a result, citizens may face with decisions that they don't understand because they are not familiar with the legal framework of the country where the main establishment DPA operates. And they may find it difficult to understand why data protection problems with companies established in their country are not solved but by the national supervisor, but by administrative or judicial authorities of another member state. On the practical side, the system will generate economic and bureaucratic burdens that will have to be supported either by the individuals or by DPAs. For instance, due to the cost of translations, the cost of translation of documents, or hiring a lawyer in a foreign country. All that could lead to a loss of relevance of DPAs in the eyes of their citizens. If DPAs are only post offices for all the cases where the main establishment is located in other state, the affected individuals would prefer to go to the national courts and not to the DPAs. And that may lead to a higher number of parallel procedures. It may very well happen that the same case is addressed by a number of administrative and judicial bodies in different member states. That will create more inconsistencies and lack of legal certainty, just the opposite, the opposite to what the system is supposed to pursue. Additionally, objections of constitutional nature have also been raised, putting into question that the protection of a fundamental right is attributed to authorities of another state. Finally, the architecture of the whole system is based on the concept of main establishment, which is difficult to define and to apply. Taking all this into account, the key question is how to reconcile more consistency and simplification for companies with effective protection of individual rights. Different alternatives have been proposed with the aim of finding a solution. One would consist in making a broad distinction between corrective powers and authorization powers. National or local DPAs would retain the competence to make decisions aimed at enforcing data protection law, particularly in response to compliance. And the main establishment authority would be competent to deal with authorization of processing operations, international transfers, consultations, etc. Cooperation and consistency mechanism would provide for coherence. Other proposal puts forward inserting co-decision mechanisms along the whole process. All decisions would be taken by all affected DPAs, be it by consensus, be it following pre-established voting rules. According to other relevant proposals, in order to enhance proximity, national DPAs should be competent to make decisions with regard to local or minor transnational cases, and the main establishment authority would be competent, acting as lead DPA, to decide on important trans-border cases. The last opinion I will mention consists in shifting decisions-making competences to the European Data Protection Board that could issue binding decisions either in cases of discrepancies among concerned authorities or on the proposal drafted by one affected DPA. Although some of these proposals improve the original design of the system, there are still points which require a more in-depth analysis to reach a really balanced and effective model. Some of them are listed in the slide, but I am not going to elaborate on them. I will stop here and give the floor to the panelists so that they can share their views with us. And following the order of the program, the first speaker is Eduardo Ustaran. Eduardo, you have the floor.
Good afternoon. I look at this audience, and when I see that it's very, very, very obvious is the amount of, is the diversity. You have all sorts of different ethnicities, and this is an international conference, and that is expected. Within Europe, we have a huge amount of diversity as well. Cultural, political,